ask the clerk to call the roll.
Senator Saslow. Senator Norman. Senator Howe. Senator Lucas.
Here.
Senator Edwards. Senator McDougal. Senator Stewart.
Here.
Senator Stanley.
Here.
Senator Reeves.
Yep.
Senator Chapin.
Here.
Senator Dees. Senator Sturtevant. Senator Peterson. Senator Peake. Senator Overton.
Here.
Very important.
All right, well, thank you very much. What we're going to do is go through some housekeeping and try to dispose of some of the bills that have Senate companions that we might be able to deal with quickly. I think that we've identified all the House patrons who have these companions that unless they object to conforming to their Senate counterpart, it's not necessary for them to be here. I assume that anybody is here who objects to conforming, that any House member will pop up and say the piece before we act on them. So first, we've got 4 bills that need to be re-referred. First, House Bill 1514, delegate salaries, dealing with healthcare practitioners, reporting disability drivers. This was a companion to a Senate bill introduced by Senator Donovan. Needs to be re-referred to the Committee on Education and Health. Is there such a motion? It's been moved and seconded. All in favor, signify by saying aye. Aye. All opposed? That bill is re-referred. Next, House Bill 1832, Delegate Kilgore's statute of limitations bill dealing with negotiable instruments is identical to bill from Senator Chapin's. Needs to be re-referred to the Commerce and Labor Committee. Senator Stewart moves, Senator Stanley seconds the motion. All in favor, signify by saying aye. Aye. All opposed? That bill is re-referred. Next is House Bill 2002, Delegate Poindexter's dealing with Department of Social Services role with respect to refugee and immigrant resettlements. Needs to be referred to the Committee on Rehabilitation and Social Services. Senator Stewart moves, Senator Lucas seconds, motion to re-refer. All in favor, signify by saying aye. Aye. All opposed? That's re-referred. Next is House Bill 2113, Delegate Keams, bill dealing with breach of payroll data and a notification requirement, similar to Senator Powell's bill, which needs to be re-referred to the Committee on Finance. Senator Howell moves, Senator Stewart seconds after referral. All in favor, signify by saying aye. Aye. All opposed? That's re-referred. Next, we have bills that are identical to Senate bills. First is House Bill 2084, and I would invite a member of the audience is here specifically in connection with any of these bills and feels compelled to be heard in connection with these to pop up and make yourself known. First is House Bill 2084. I see Delegate Herring here. It deals with search warrants. It's identical to Senator Black's 1260, which was reported from this committee, 14-0, and passed the Senate 40-0. Is there anybody who can help me heard? Hearing nobody, has been moved to be reported. All in favor, signify by saying aye. Aye. All opposed, that's reported. Next is House Bill 2287, Delegate Collins, dealing with confidentiality of juvenile records, identical to Senator McDougal's bill with the same type, reported from this committee, 15-0, passed the Senate 40-0. Is there a motion? Moved and seconded. All in favor, signify by saying aye. Aye. Next, Delegate Collins, House Bill 2328, dealing with inability to pay fees on account of poverty, identical to Senator Vogel's 1305, which likewise came through uncontested. Is there a motion on that? Second. It's been manner in which this bill left the Senate?
He's okay.
Right. It's been moved
Second.
and seconded to conform in that report, correct?
Yes.
All in favor, signify by saying aye.
Aye.
All opposed. Next, we have several bills that are similar, but on which there were some dissenting votes, and I try to draw this to your attention. To refresh your recollection, first is House Bill 1746, Delegate Rush's bill dealing with possession of epinephrine on college campuses. My recollection is that this conforms the practice on college campuses to the practice that exists for primary and secondary schools that passed out of the committee 12-2 with Senators Deeds and Peterson voting no. If there is an inclination, appropriate motion would be to conform to Senator Chapin's bill 944 and report.
I believe it be conformed to second.
It's been moved and seconded. All in favor, signify by saying aye. Aye. All opposed? Next is Delegate Gilbert's House Bill 1852, dealing with carrying handguns while under protective order, similar to Senator Vogel's 1299, which reported from courts 12-3, and out of the Senate 27-13. In this committee, Senators Powell, Lucas, and Deeds voted no. Is there a motion to conform in the report?
So moved.
It's been moved and seconded that that bill be conformed and reported. All in favor, signify by saying aye.
Aye.
All opposed?
No.
It is 18. And last on this list is House Bill 1853, Delegate Gilbert's bill dealing with firearm safety training courses for victims of domestic violence, which is similar to Senator Vogel's Senate Bill 1300. It passed out of this committee 15-0 and out of finance 16-0, but passed the Senate 28-12. So some people may have had a change of heart. I cannot recall what they were, so you vote your conscience. Is there a motion to conform to Senate Bill 1300 and re-refer to the committee? I recommend to conform, report, and re-refer to finance.
Second.
It's been moved and seconded. All in favor, signify by saying aye. Aye. All opposed? All right. That is reported, re-referred to finance. Next, we have a sign-up list. All right, Delegate Pogge, 2369.
Thank you, Mr. Chairman. It's a pretty simple bill dealing with concealed handgun permits. Currently, there is no requirement to show proof of address when initially applying for a concealed handgun permit. You would think there would be no need to require commuter proof when you are just changing the address on the permit. So what my bill does is removes that requirement to provide proof when changing your address, proof of new address, since you don't have to do it when you initially apply. It would keep the permit requirements and the change of address requirements consistent in the code.
All right, state police have any problems with this?
No, Mr. Chairman.
All right, anybody have any questions or patron?
No report.
Anybody from the audience wish to be heard in connection with this? It's been moved and seconded that the bill be reported. All in favor signify by saying aye.
Aye.
All opposed? That bill is reported. Thank you very much. Delegate Yost, 2324. And for the, while Delegate Yost is coming up, just for the House patrons who are here, I just want to remind you, our practices in the Senate and our rules are a little bit different from the House rules. You all have a practice of laying bills on the table, which we don't have. And we've got two options. We either report or pass by indefinitely. And all of us have about half of our bills pass by indefinitely.
He's not gonna sleep right here.
So tell us about your outstanding bill, Yost. Anybody have a motion?
This is House Bill 2324. This adds the use of prepaid debit cards on a method in which to pay insurers. This is brought to you on behalf of the Treasurers Association of Virginia and several counties who are already been doing this, particularly in the rural areas of the state. Neither are not explicit about to do it by code, so this grant is legally.
And I did just have a quick question. I know that we were doing this with tax refunds and that there was a huge outcry in opposition to this. I know that this doesn't mandate, it simply provides another option. But aren't we moving away from that?
That I do not know. I know the outcry came from when you were using the card as part of the transaction fee. I believe is what the concern was. The bill actually puts in place that individuals make at least one withdrawal, one transaction without a fee.
Is the notion behind that the one transaction is either going to be putting into your bank account or cashing it?
Yes, sir.
All right. Anybody have any questions of the patron? Anybody from the audience have any thoughts, either pro or con, with respect to this bill?
Good report.
Been moved and seconded that 2324 be reported. All in favor, signify by saying aye.
Aye.
All opposed, that bill is reported. Thank you. Next, we've got Delegate Killian, elsewhere. Delegate Fowler, elsewhere. Delegate Moorfield.
Mr. Chairman, members of the committee.
1329.
Yes, sir. House Bill 2329 is a technical correction that would add the division of Capitol Police to the list of agencies and make them rest without a warrant.
Okay. Anybody have a question of the patron? I'll resist. Anybody have any comment, pro or con?
Can I ask a question?
Yeah, go right ahead.
I mean, right now, if the Capitol Police arrest someone, do they have to go get a warrant, or do they just haul them off?
Well, this actually came at their request. Apparently, the agency was inadvertently admitted to the list of law agencies that could perform arrest without a warrant. The case of performing a crime.
So I guess I see the gentleman behind you wants to say. I guess my question is, what have been the practice to date? I can't imagine you went and got that warrant.
Mr. Chairman, in answer to the gentleman's question, I would say that we have, Seawood on behalf of the Capitol Police. Our agency has derivative authority under 30-4.2:1, wherein we have all of the powers of a police officer of the city of Richmond when we're exercising our duties. This clarifies and adds us to the statute. So we presently can do it, but it would be nice to fix this. Thanks, Senator Reed.
Anybody have any other questions? It's been moved and seconded that this fine bill be reported. All in favor, signify by saying aye. Aye. All opposed? That bill reports. Delegate Killian, you ready? Sure.
Should be Senator.
2166.
Thank you, Mr. Chairman. 2166 is a part of the opioid package that we're trying to produce.
Say that 3 times.
Opioid package we're trying to produce anyway. So this actually was brought before me by the work group of judges and public attorneys in Southwest Virginia. And what this bill does is it currently Class 1 and Class 2, Schedule 1 and Schedule 2 are grouped in the Virginia Crime Code, and they're not differentiated. So what this piece of legislation would do would take the top 11 most commonly abused substances and pull those out so we can better track them throughout the Commonwealth. It also takes out epinephrine, which is Suboxone, which is also commonly used in Southwest Virginia throughout the Commonwealth.
All right. And Delegate asked me about this a little while ago, and my recollection is refreshed. Council, I think, had some technical concerns about whether this was unintentionally, inadvertently going to alter the substantive law, and maybe
Mr. Chairman. Currently, the crime is possessing any Schedule 1 or 2 drug. And breaking it out as this bill does raises questions of what would happen if drugs were mixed together, if you had a combination of controlled substances. Does that then permit only one prosecution? Whereas under current law, you would be permitted to prosecute for 2 separate offenses. More broadly, our concern was this. This section and the drug laws in general in this state have such a substantive body of case law and jurisprudence that's already developed. Our concern was that this might produce unintended consequences. It might cause a dramatic and substantive change in established case law, which quickly we agreed as we couldn't completely anticipate. And so I have some caution there that this could cause an unintended change in the law. A suggestion was that if it's data that is the goal of the bill, that data might be best captured by adding a box to the sentencing guideline sheets that would permit the probation officer preparing the sentencing guidelines or whoever handles that to note on the guideline sheet what substances are the subject of the prosecution so that that data to be captured and kept by the Sentencing Commission. And that seemed a different way to achieve the same result, if I understand the patron's purpose, rather than potentially affecting substantive criminal law.
I don't know whether you want to phone for help and see what the Commonwealth's attorneys would.
As Chairman, I was on the phone.
Just a quick question.
Senator Reeves.
Like, I'm looking at your schedule here and I don't see MDMA. So I was wondering if you alluded to this.
Mr. Chairman, Senator Reeves, that was another concern of the committee, was that this would require constant amendment in order to add whatever drug is currently a subject of abuse at any particular time.
Isn't that covered in number 12?
Yes. It is.
So,
If it's a Schedule 1 or 2.
which is what the current law addresses.
Correct.
Seems like we've got 2 choices here. One is to add a provision, as counsel suggests, that would require tracking through the, through forms. And number 2 would be to track the prior language and put any of the following substances so that it tracks as nearly as possible the current law.
That's correct, Mr. Chairman. On line 20, you would reinsert the word any, and on line 21, you insert the word of between words B and B.
Or else on line 20 to put any of.
Correct.
Senator McDougal.
Is the purpose really to collect information? Is that what we're trying to do?
Yes.
Mr. Chairman, I'd say that might need to be another, in the BCC codes, the Supreme Court collects and required, it's good to have a different BCC code for each type of substance. I'm very supportive of the concept of what you're trying to do to get the data on the different information, but I think what some of us in practice have some concerns that when you start separating it out, we find that we pop into challenges that we were not anticipating by listing them out specifically. That, as long as I can remember, it's done in Schedule 1 and Schedule 2, and it is a pretty substantive departure from the way they're not individual.
Mr. Chairman. Justin Lynch, Attorney Ross County, City of Jordan. Regarding this piece of legislation, this is part of a larger whole of a series of bills that are aimed to tackle the substance abuse crisis in Southwest Virginia. And in particular, I just want to echo what W. Pillen said with regard to the purpose of this particular piece of legislation was a product of a working group of judges and Commonwealth attorneys who came up with this as
a potential solution to our question of the most abused drugs that we see, how to specifically track those numbers. We did not, and I'm not speaking on behalf of the Commonwealth Attorneys Association, I'm speaking on my own. The Commonwealth Attorneys Association is not taking a position, but I would say that we do not anticipate any unintended consequences with it, as are outlined. I understand.
Mr. Chairman, can I ask a specific question? The way you have it drafted, if you have cocaine displaced with fentanyl, not that uncommon or heroin with fentanyl, is that now 2 charges? Or is that 1 charge? Because you're going to get a charge for possession of cocaine and another charge for possession of fentanyl?
Let me help. It would only commit 1 charge, the way it's drafted. And I know that's not what the patron intended, but that's an example of one of our concerns of unintended consequences. We don't, in other words, we don't want to decriminalize drug possession, as drafted was to do.
Here's my suggestion. Maybe that Delegate Fillion and Mr. Slamp step aside and see if they can come up with reporting language that they can either run by us or secure assistance from counsel in putting together. And we'd be happy to try and return to this today if we would really like to return to this today. Okay? All right. Just go back temporarily. Next, we've got Delegate Fowler. 1466.
Thank you, Mr. Chairman. Mr. Chairman, House Bill 1466 simply provides that the clerk of the court has the capability to send an electronic renewal notice to concealed carry permit holders, and if the concealed carry permit holder requests such a notice on his concealed carry application form, then the clerk that issued the permit shall notify the permit holder by email at least 90 days prior to the expiration of his concealed carry permit. Mr. Chairman, I think the notice in the proposed legislation is failure to send or failure to receive the email does not extend the validity of the permit past the expiration date. And finally, I'm saying that appreciate the Clerks Association helping me with this bill, and they do support House Bill 1467.
So, Mr. Diggs, you love this bill?
Mr. Chairman, we are in love with this bill.
Thanks, Mike.
The Delegate Fowler.
Hard to clear that. All right. Anybody have any questions of the patron? Anybody in the audience wish to be heard in favor of or in opposition to this bill? Fine, bill is before us. It's been moved and seconded. The bill be reported. All in favor, signify by saying aye. All opposed, that bill is reported. Thank you very much. And next we've got Delegate Freitas, Delegate Ferris, Delegate Klingenfelder. Pleasure.
Mr. Chairman, at the request of one of your members, I believe that one of these bills will be for today until he's able to be present to discuss it.
Without objection, 1554 will be back for today.
Check it out on the.
Mr. Chairman, may we take up 1392?
1392.
Chairman, let me give you a little background on this, and then there'll be a substitute that I would ask you to adopt, and then we will potentially be administering an amendment to the substitute. Secretary Moran and I have a sidebar on.
Right. Senator Stewart moves, Senator Stanley seconds the adoption of substitute. All in favor, signify by saying aye. Aye. All opposed, the substitute is before us.
Mr. Chairman, this bill is the school security bill. You passed it out last year. The governor vetoed it. And he vetoed it citing some defects that he wanted addressed. I listened carefully to those defects as he thought they were. And in the version that is before you, I incorporated some changes. So let me just take you through the problem set, the bill, and then and I'll highlight the amendments that are in this substitute. They're different from the English version. We've got two kinds of security officers. We have school resource officers who are employees of your local law enforcement. And then you have, and they can carry a firearm in the school, and many do, and they are deployed around schools. And then you have school security officers. These folks are not permitted to carry firearms. And the problem is that you've got school districts, some rural, that simply don't have the resources to put a school resource officer in every school to protect the kids and teachers. So this is a local option bill that would authorize school security officers, if the locality wanted them to do it, in the performance of their duties, if they were retired law enforcement officers who retired or resigned in good standing. And one of the amendments that you will consider that is in this substitute says that they have to have been retired law enforcement within the last 10 years. So we're not hiring somebody who is well beyond their years to perform this duty to the level we would want them to. That person, the SSO meets the additional training and certification requirements of the Department of Criminal Justice Services, the local school boards, and the local school boards is new. This is one of the changes I put in this year. The local law enforcement officer, the local chief law enforcement officer also gets a chance to weigh in and provide input to the school board on the people that the school board is going to hire. A practical example there, this is one of the aspects the government was concerned about last year. The practical application there is that way law enforcement has a chance to look at the list of people. And just to ensure that we have people of the quality and performance expectation that you would want to do this job. And that the local school board grants that person the authority actually to carry that firearm. The bill also requires the DCJS establish additional firearms training and certification requirements for school security officers who carry firearm performance in their duties. Existing law requires DCJS, by the way, to establish minimal training and certification requirements for school security officers. Mr. Chairman, if the committee would turn to page 11 of the substitute. And if you look at lines 283, beginning at little I, to the, right on through to little I, you'll see that we have included in this substitute the requirement that an individual has to have been retired within the last 10 years. And if you look on, and this was the recommend, this is a governor's amendment essentially from the Department of Public Safety. And then if you look on lines 289, you will see the word beginning verification of such law enforcement officer that he is not prohibited by state or federal law from possessing, purchasing, or transporting a firearm. The Secretary wanted this language included to make sure that we had a loophole when we were hiring someone who otherwise wouldn't be authorized to carry a firearm. So those are two very good amendments that I have agreed to accept in the first version. And Mr. Chairman, the last thing that I will point to you is not before you as an amendment, but I am prepared to offer it, would be found on page number 8. And if you go to the center of the page on line 196, my amendment there would be very straightforward. Put a period after duties and strike the remainder of that sentence. Mr. Chairman, you and I spoke earlier before the committee convened. This bill was introduced on the 1st of July of this year. It's been out there on LIS for everybody to see. I got a subsequent financial impact statement the day it was engrossed out of the House and came over to you for $75,000. We've had a sidebar. I'm sure the Secretary is here to make comment. This was their recommendation that if we strike this language, it should remove any impact of the $75,000.
All right, so if you would consider that a friendly amendment then?
I would.
Secretary Chafin.
Second.
Substitutes before us, right?
The bill, that is the bill, Mr. Chairman.
Okay, Senator Chapin moves, Senator Reeves seconds the amendment on 196, adding period after duties and striking the remainder of that sentence. Any discussion of that amendment? All in favor of that amendment, signify by saying aye. Aye. All opposed, that amendment is made. Let's hear, any member of the committee have any questions to the patron? Let's hear from, I guess you got supporters.
Well, I support it.
All right.
I'm sure there are supporters, but this is a bill that, we've looked at this bill a lot, Mr. Chairman.
All right.
Type of thing.
Opposition, yes, sir.
Mr. Chairman, Andrew Gillard, Virginia Center for Public Safety. We commend the delegate for bringing this bill. We had some problems last year, and he changed the language, and we have no objection. I like the language changes this year, and I like what I'm hearing. I would just say, though, that I hope that in light of recent events, that the training offered by the DCGS will cover specific instructions on how to counter grizzly bear attacks.
All right.
However, on a slightly more serious note, there are a couple of concerns that we still have. And one of them is that I'm pretty sure that this time next year I'm going to be standing in front of this podium trying to convince you not to strike the language about this being offered only to retired police officers. I've seen a bill like that this year. You won't get to see it, but it's in the air. You don't have to be a tea leaf reader to know what's coming. And I don't think that we need to extend this to anything other than police officers. My final comment would be to look at the data. If you look at the data provided by the Department of Education and the CDC, you'll see that when you look at the violent victimization of school children in school premises and on their way to and from the school, only 1%, actually slightly under 1% of children that are killed in violence are killed while they're at their school or on their way to or from the school. That means that 99% of the children are killed in their homes and on the streets. While this bill is an excellent way of approaching that 1%, and I wish it was a 0%, I wish no children were killed, I'd like you to remember before you vote on this and feel good about attacking that 1%, that we've done nothing for the 99% that are going to die in their homes, most of them with the guns that are being purchased for their protection. So before you feel good about doing something about the 1%, remember the 99%.
Thank you.
Good afternoon, Warren Haas with the Educational Fund of Scotland Wellington. I appreciate the delegates' efforts in this area. I think I'm still a little bit confused about whether persons other than retired law enforcement officers are going to be allowed to get this supposed training from the BCSCS. And if this puts a burden on the BCSCS with regard to coming up with this training, it says the department shall establish additional standards and certification requirements for school security officers who do carry a firearm in the performance of their duty. So that captures a population other than retired law enforcement who do have the proper training. They undergo hundreds of hours, fight or flight situations, active shooter situations, retention, muscle memory, judgment, and all of those require hundreds of hours of training. And our law enforcement officers subject themselves to that to meet the standards when they're employed. And by in the other section under lines 281, we're saying that these law enforcement officers have to have that detailed training, but I'm confused, I have to be honest, if we're requiring that of the school security officers. So I'd just like to understand the bill before I wholly support it. Thank you.
Mr. Chairman, when you heard Dr. Gaskin, I don't know how the case got in there, just seeing the substitute. But I wanted to call to your attention some concerns that we would have about the way the substitute is interpreted. If you look at lines 285, it uses law enforcement officer in good standing. I don't know what that means. Does it mean that he or she wasn't fired by a prior law enforcement agency? Because, the certification requirement says that you can keep your license to police in Virginia if you haven't been convicted of a felony or certain misdemeanors, or if you haven't met the mandatory training standards. But it doesn't say anything about whether you've engaged in repeated acts of use of force or other misconduct. In fact, the Assembly has not chosen to incorporate misconduct as one of the reasons why you could lose your certificate. So if you look at 285, it says in good standing, which is undefined, and then it goes on and says met additional training and certification requirements, but it isn't clear whether a person who was fired by a police department or allowed to resign by a police department because of multiple misconduct issues could in fact qualify under these standards the way they're written. And that would obviously be of serious concern. And then, I mean, generally, I will say that the ACLU is not generally supportive of increasing the number of people in our schools who are engaged in law enforcement in schools, because to our experience, those officers, rather than being focused on protecting the students in the school from outside forces, have been more often currently focused on the students themselves, and has led to disparate discipline and disparate referrals to law enforcement and external law enforcement, well documented in Virginia. So, you know, just general concerns. I know that Patriot is working really hard to try to make this make sense, and I understand that there are many rural localities where having fully trained police officers in this role presents a significant financial barrier. But I think we need to be conscious about who it is who might end up in these positions, given these standards the way they're currently expressed.
Thank you. Mr. Chairman, if I could just address a couple of things to me. First of all, that's precisely, what you just heard is precisely why the law enforcement agencies for the locality are involved in the vetting process. So that I think is adequately addressed, and I think that that's why we put it there, and it was pursuant to what the governor said last year's ago. We really need to include that. So I would suggest to you that good standing means exactly what it says. And if you've been fired, you're not in good standing. And again, that's why you're going to have local law enforcement look at you. That is a very good safeguard that we incorporated. I think ultimately we have to look at it in the reality that sometimes law enforcement can't get their faces. They just can't. So this is a good bill. We included the governor's concerns. And Mr. Chairman, if I could, just as a point of personal privilege quickly, many of you may not know this, but I have generally not been supportive of just allowing anybody to carry a firearm in a school. And I've made that point clear to members on my side of the General Assembly. It has not been the most popular thing I've ever said. I believe this is fundamentally the responsible way to ensure that kids and teachers are protected, is to have people who are well trained to do this. I hope that in a bipartisan way we can all support this. Thank you.
All right. Any member of the committee have any questions or comments? Ms. Benjamin, you look,
Mr. Chairman, no, I did spot precisely the same concern that Claire articulated, and I don't mean to do any harm to the bill or damage it, but the committee heard earlier in the session when another bill was presented permitting the disclosure of information by one law enforcement agency to another. And the committee heard of situations where officers are permitted to resign rather than be fired for misconduct or unlawful use of force reason, and then go to another agency seeking employment. And the purpose of that bill, and I don't remember what happened to it, was to permit a fuller disclosure of the circumstances of an officer being permitted to resign. Apparently, we were told law enforcement agencies don't disclose or aren't comfortable disclosing that information. My point is that the requirement, the sincere and well-motivated requirement that they be in good standing may be meaningless or may not have the force and effect that the patron intends. The other concern, and Charles caught this because of the amendment on page 8, the question was that would leave the question of who would administer the additional training certification that is required on lines 286 and 287 if that amendment is made on page 8, if I understood.
That would be at the local level. Many of these retired police officers now are permitted, Mr. Chairman, to carry their firearms as if they were law enforcement when they're retired, so long as they maintain their certification. And you have law enforcement officers in all of your jurisdictions who routinely go out with their active forces to maintain their currency and their training. So that will be done at the local level.
Have any comments about the good standing issue?
I don't know how to fix it. We've had this out there since the 1st of July. This is the first time the issue has come up. It certainly didn't come up on our side of the house, and I don't remember Claire testifying to that effect on our side of the house, or the General Assembly either. So, you know, I don't know that I'm smart enough to fix it right this second. And frankly speaking, I don't think it needs to be fixed. I think that's why you have law enforcement involved to look at these guys. They're going to be able to find out this information.
It does require the school division to solicit input from the.
Right.
Which is one of the things the governor wants.
Mr. Chairman, again, I'm looking at this, and there, throughout this whole paragraph on page 11, there are numerous safeguards in place, not the least of which is the final sentence, which allows the local school board to give this authority. If they're not comfortable with this individual, they simply are not going to grant the authority. There is increased training involved in this, more than you would typically have, quite frankly. That I'm going to go here with both.
Second.
All right, it's been moved and seconded that the amendment, the nature substitute, as amended, be reported and re-referred to the Committee on Finance. Okay. All right, all in favor, signify by saying aye.
Aye.
All opposed?
Only two? I don't know based on the way that the attorney.
What's the vote? 12 to 2, bill is reported and re-referred to Finance.
1991, Mr. Chairman. 1791, I'm sorry.
1791.
Mr. Chairman, I'm going to share with you what this bill is unamended at this point, but I had a chance to speak to Mr. Benjamin. He has got some thoughts. Actually, I think my suggestion is not necessary. I think as written, it works. Mr. Chairman, this bill provides that any person who conspires with others to cause or produce a riot or directs or incites or solicits other persons to participate in creating a riot or acts of force or violence against a law enforcement officer, a firefighter, volunteer firefighter, emergency medical service personnel, or members of the Guard or the Defense Force is guilty of Class 3 felony. We have added into this bill, Mr. Chairman, they have to be in the performance of their duties when they do this. So I hope that we will pass this additional protection for our first responders. We certainly precedent within the law to cite first responders, particularly here, and I hope this will pass this bill.
All right, any member of the committee have any questions of the patron?
Yeah, I got a question.
Senator Peterson.
You know, long before I got up to here, I was a young person, and I said some pretty stupid things. And now that young people say stupid things and they end up on Facebook or Instagram or what have you, it seems to me like Lingenfelder is a pretty broad standard of saying directs, incites, or solicits other persons. So it's not even a conspiracy. You don't need to have an agreement. You can simply say something. It could be taken as promoting violence or inciting violence, even if you didn't necessarily intend it to be that way, or even if you just said something stupid. And now you're going to get charged with causing a riot.
What I'd say in response is that's why we have prosecutors who look at this stuff and do so carefully and say, do I really bring this to trial? Do I, guys in a rage, I mean, you've got people out there who do assassination talk, okay? They don't wind up getting prosecuted because you have good, smart prosecutors who look at this stuff and they make decisions, they use their discretion in looking at it. And I think they can detect between, a Twitter rage and something that in fact was seriously contemplated as a conspiracy.
Senator Stewart. I'm sorry.
Senator
Stewart.
Mr. Chairman, I just want to commend the Colonel for bringing this bill. I tried 3 of them. I had three bills.
I stole it, Mr. Chairman.
None of them made it through.
I hope you have better luck than your, Senator Edwards.
Particular event give rise to this particular,
I think-
it's already a class 5 felony, to expire and so forth.
I think that, the thing that caught my attention, Senator Edwards, was the incident in Dallas where we had police officers gunned down, just gunned down.
Murder.
And, yeah, they were murdered. And I have not tried to sensationalize this with trying to point to any one incident, because that's not why I think we're down here. What I'd like to do, though, is get in our code a very clear picture that we're just not going to tolerate this in Virginia. And so I'm hoping that what we'll do here is prospectively ensure that we don't have this kind of violence in our working economy. Honestly, I have not tried to sensationalize a lot of examples, but I think there's ample evidence out there that law enforcement has been really threatened in the country in the last several years.
All right, any members of the audience wish to be heard in connection with this bill? In favor, in opposition? Step up.
Good morning, Chairman, members of the committee. My name is Charles Schmidt with the East City of Virginia. We oppose this bill on the House side. Again, we understand what the delegate is trying to do. Virginia already sent a clear message as far as the enhanced penalties of actual violence towards police officer, enhanced penalties for spitting on assault, all kinds of areas in the code. We think that the police are protected. Our issue with this is obviously these sort of enhanced penalties that, as Senator Peterson pointed out, any such enhanced penalties that make it more of a crime and susceptible to more time in jail for voicing concerns out of protest or out at some sort of assembly that is declared a riot, that those people that what they say will get them in more trouble than what actually happens as far as an assault with a police officer. It's very troubling for us. So we would strongly oppose the bill.
All right, thank you very much. Anybody else wish to address the bill? Any other questions? Bill before us. Senator Peterson.
Yeah, and, my love and affection for Delegate Lakeland's daughter is not going to compel me to support it.
That's well known in this body.
And here's why. You know, we have assault on a police officer, which is a felony right now. It's a class 6 felony, as opposed to if I just push Senator Deeds or whomever else. And we've Christmas treed to that. We've added everybody from the school crossing guard to, magistrates to nurses to doctors to emergency room doctors. Now we have to make a list of people that you can't assault without it being a felony. And the same thing's going to happen here. And I just worry about, look, if you conspire to create a riot, that's a felony right now. And now we're going to start carving out classes of people that are, more equal than others, for lack of a better term, and we're going to add to it for the next 10 years. So, anyways, I saw it passed unanimously in the House. I'm going to vote against it now, so we'll see what happens.
Is there a motion?
Move to that, second.
All right, it's been moved and seconded to pass bill by
Substitute.
motion.
Mr. Chairman, I would just note for everyone that this, I went through this development, talk about free speech, peaceful protests and things like that. And that's not what the bill says. It says riot acts of force or violence. That's what it's directed to. I tend to agree with Delegate Lindenfeld. You just can't have that in a civilized society.
Now,
I don't have to report to them.
well, yeah. Mr. Benjamin was doing a good job of biting his tongue and letting his roll, but Mr. Benjamin has some thoughts.
I have a problem agreeing with everyone. The patron's absolutely right, as are the supporters of the bill, but so is Senator Peterson. Mr. Chairman, it's easy to identify, as Senator Stewart does, it's easy to identify those situations where enhanced punishment is absolutely necessary. But it's equally easy to imagine those situations where, as Senator Peterson says, young kids who mean well to stand up and participate by voicing their anger and their concern and getting in people's faces and sometimes chanting really stupid, violent sounding stuff, well, now you're criminalizing their speech, and not only criminalizing it, you are making it a class 3 felony. That carries 5 to 20 years. So, yes, the bill reaches its intended targets, but it also reaches its unintended targets at the price of kids and stupid people exercising their right to protest, sometimes very loudly and angrily. And so that's why I agree with everyone.
Mr. Chairman. All right, Senator Shastroff. Mr. Chairman, I told the people who were there that when I was a kid, everybody used to say, Shastroff, you're a riot. Now I'm going to be a class 2 felon.
Let's wrap it up. We've got a motion and a second. Now we have I don't know that anything is going to change.
Mr. Chairman, let me just point out again on line 14, I think it's important, directs, incites, or solicits other persons who participate in a riot to acts of violence. Because this is not about speech. This is about getting someone to kill a cop, shoot a fireman, shoot a National Guardsman, do something that takes someone's life who is on duty to protect life. So I think PBI this, I hope that you won't. And I hope that there will be a substitute motion to report it.
There is.
Mr. Chairman, speaking to the bill, to the motion, it's already $75.
Wait, just a second. All right. Steve?
One tightening of this, Mr. Chairman, might be if you made it the crime for someone to, instead of direct, incites, or solicits, that you make the crime one who intentionally causes acts of force or violence by participants in a riot against a law enforcement officer. That I will say is only somewhat better to my concerns, but it does tighten it a little bit.
Mr. Chair, I think if that's the case, then you could have a second-degree homicide or accomplice before the fact at that point.
Here's my concern, my unease really, is that the language directs, incites, or solicits doesn't require that there be acts of violence. And my concern is that it permits prosecution just for an attempt.
Irrespective of whether an act of violence results.
Correct.
All right.
Can I just ask Steve one question?
Senator Reeves, we're going to have to bring this to a head.
Just a real quick question.
Go ahead.
In this scenario, because I've been in riots here and I had a shield, and I have people in front of me, and on the peripheral of this mob of protesters, maybe the people in front of me aren't doing anything, but I've been tasked with moving forward to disperse the people on the streets. It's not a riot, because nothing is broken, but they're still out there, but there's some peripheral kids on the outside, maybe they start throwing rocks and I'm out in the middle, and one of those shields hit me, or maybe I hit the shield and try to get away. Would I be prosecuted under this?
Would who be prosecuted?
If I'm one of the protesters.
If you're a protester.
If I'm a protester, and I've got a police with a riot shield coming after me, like trying to force me out, and I hit that shield, would that be considered to be prosecuted for this under that?
Yes. You're participating. See, a riot is defined as any, it's defined as the unlawful use of force or violence by 3 or more people. And
knowingly, Mr. Chairman,
May I make a suggestion? I think Senator Stewart has a suggestion that he's prepared to make. The motions be withdrawn.
I withdraw my substitute.
John? Withdraw the motion, is that right?
All right, I'll withdraw it.
All right. Senator Stewart?
Mr. Chairman, I hear what Mr. Benjamin is saying and concern regarding this. So what I would propose is on line 12, we strike the word solicits, and on line 15, we strike the word solicits. And then we just have
Chapin.
Yes.
Senator Deeds. Senator Sturdivant.
Yes.
Senator Peterson.
No.
Senator Pete.
Yes, by proxy.
Senator Rubenstein.
Yes.
8 ayes, 6 nays.
Sorry.
8 ayes, 6 nays.
86, the bill is amended reports. Here's the order we've got just for reference, and we're happy to call people. We've got Delegate Freitas, Ferris, Herrick, Marshall, Bob Marshall, Danny Marshall, and Pease. So if you want us to call you, we'll call you. Delegate Freitas.
Thank you, Mr. Chairman, members of the committee. What HB 2024 does is it puts into the code a required.
Second, Delegate, I think we've got a substitute. All right, Delegate, tell us, Senator Stewart moves, Senator McDougal seconds the adoption of the substitute. All in favor, signify by saying aye. All opposed. Substitutes before us. Tell us what the problem is first, Delegate.
The problem right now, Mr. Chairman, is that technically there is no minimum requirement for notification to a property owner should they be engaged in a quick take. So essentially this has to do with a very abbreviated form of eminent domain. And obviously a lot of agencies out there already have some reporting criteria and reporting requirements that they've implemented, but there's nothing in the code that requires it. And so what we're trying to do here is to ensure that if a property owner is going to have property taken as a result of quick take, that there is some notification that is required to take place before that procedure goes forward.
So my understanding is sometimes when these quick takes occur, the first property owner learns of it is when a bulldozer is moving in.
That has happened before.
All right, and this requires 30 days prior notice before a quick take certificate is filed. And it also provides that when it's filed, because sometimes they may tell you a year in advance, and then not tell you when it's actually filed. Even then, you find out when the bulldozer shows up. But this requires that notice be given within 48 hours of the filing or recording of the certificate. Is that right?
That's correct, Mr.
I
Chairman.
think Senator McDougal maybe has a suggestion for a line amendment.
Mr. Chairman.
Mine, 16 and 30, I thought we were trying to move away from the registry.
So your motion would be to make it mail?
Mr. Chairman, I use registered mail because that is used on August 13 and 27 for the notice.
All right. All right, so this is before the committee. Well, wait a second, let's give supporters and opponents an opportunity to be heard.
Mr. Chairman, members of the committee, I'm Steve Rossi, representing the Family Foundation of Virginia. We support the amended version of the bill. Thank you, sir.
Mr. Chairman, Roger Wiley on behalf of PAYCO and VML. We did not oppose the bill as it came out of the House. It's not clear to me whether you're doing something different to it now.
We've got a substitute.
I've not seen that.
It's got a ways to travel.
Well, Mr. Chairman, for starters, I don't know how you measure 48 hours if you're doing the notice by registered mail. Is it from the time you put it in the mailbox? Is it from the time the receipt is signed? It adds a lot of uncertainty on the bill.
About that, would you be delegate? Would it satisfy you if it was mailing within 48 hours? Postmark?
Yeah, I'm not sure why we're adding this second notification. There are already about 3 notices that take place. in some cases even more than that. If the project is involved or rezoning, they're even more than that. But at a minimum, there's a notice when the project is approved in the capital improvements plan, all the affected landowners get notice then. There's another public hearing at the, not a public hearing, but a public notice requirement at the time of entry onto the property for surveying purposes. And then there's the notice that's already in the law when you file a certificate. So I'm not sure why we add this fourth notice at the end, 2 days before something happens. Or after. 2 days. Within 30 days of the filing. You're right, I did not read that as being after, but yeah, within is either way. I just am not sure I understand the reason for that last.
Mr. Chairman, Chris Costa, Fairfax County, we were fine with the way it came out of the House, and I don't know what these changes are, so I need to look it up with the feeling. If the 15 days we had before is changing to 30 days, that doesn't sound like something that we would be okay with, but we do 15 days.
Would not be okay in 30 days?
Well, I think that there was kind of an agreement on the 15. That, to me, though, is less of a problem than the addition of this.
Under the bill as it came out of the House, my understanding is you notify, tell the property owner a year in advance, hey, we're gonna file a quick take sometime on your property. And they never know what your timetable is, sometimes until bulldozers show up.
No, I'm not sure that's the current law, but I don't have a lot of problem with the notice provision there added to the House, even 15 days worth.
I have some familiarity with this. This is actually a good bill. I don't know if Dell is listening to me, but anyways.
He is now.
Oftentimes, these processes take years to play out, so you can give notice of capital improvement plan that will have been years previous.
Sure.
So what this is doing is making sure that the date when the actual quick take certificate is filed, you're actually giving notice that contemporaneous with that event, which is really the event that actually means something. So I think it's a good idea, and it's gonna cost you an extra 55 cents on an envelope. Yes, sir, it will. I'm sorry.
I'm not worried about the cost. That's not that cost. What I am worried about is something that slows down the overall process.
Well, it's gonna take you 30 seconds to walk through a mailbox. So,
Mr. Chairman, I second Christian's commissioner's report.
All right, the motion has been made and seconded that the amendment in the nature of the substitute be reported. All in favor, signify by saying aye. Aye. All opposed? Bill is reported. Thank you. Next, we've got Delegate Ferris, 2325.
Yes, sir, Mr. Chairman, I think 2325 is a pretty self-explanatory deal in the fact that.
You have a good story to tell us?
Mr. Chairman, we all do get $100.
He's already on my payroll.
Right. Mr. Chairman, evidently somebody went to get their gun concealed carry permit reviewed and did not want to show their picture ID, photo ID, so they, this bill just clarifies that they have to do that. They've been taking care of it in the past by the fact that it had to be notarized, but we feel like the clerks are smart enough to look at a person, look at their photo ID and take care of this in one fell swoop.
So you're okay with photo ID?
Yes, sir.
All right. Hope everybody is. In this instance.
Yes, got to show photo ID for everything else.
I know. I'm glad we all come around. Mr. Chairman,
Yes, sir. I've been reminding some of our colleagues that if you want to go to the executive branch office building, you have to show your photo ID 2 times.
within 15 feet of each other. It's been moved and seconded. All in favor, signify by saying aye. I'm sorry, wait a second. Anybody in the audience wish to be heard in favor of the opposition to this bill?
The clerks are smart enough to handle this, Mr. Chairman.
All right, all in favor of reporting, signify by saying aye. Aye. All opposed, that bill is reported. Thank you very much. Delegate Hurdick. 1903.
Thank you, Mr. Chairman. Senators, House Bill 1903 would extend 540 admissibility of ordinary business records and criminal proceedings on the same procedures that currently exist in civil proceedings, amending section 8.01390.3 of the Code of Virginia and derivative G, the Virginia Rules of Evidence. In support of this bill, Mr. Chairman, we have representatives of multiple Commonwealth Attorney's offices together with the Virginia Indigent Defense Commission will rise in favor of the bill.
All right, we'd be happy to hear from anybody.
Mr. Chairman, Chester Slim, Commonwealth Attorney, Washington County, City of Norton, the Commonwealth Attorney Association supports this bill.
And there's a bunch of them.
All right, anybody else?
Maria Jankowski, Commission. We support it also.
All right. Do you have a question or?
Move report.
Some gears are rolling. All right, it's been moved to report. Is there a second? It's been moved and seconded. All in favor, signify by saying aye.
Aye.
All opposed?
Thank you, Mr. Chairman.
Note your nose. Next, we've got Delegate Marshall, 1468.
Thank you, Mr. Chairman. 1468 is identical to a measure that passed last year, both the House and the Senate, with the exception of 7 words on line 18, which were removed at the request of the Virginia sheriffs. This requires that any incarceration facility in Virginia would honor a retainer request from U.S. Immigration and Customs Enforcement and not release an individual prior to that time. You can't hold an alien beyond that time, except if federal or state law allows the holding of that person. That is up to 2 days as far as I know. Mr. Chairman, the status of compliance with ICE detainers, let me read some information to you. A FOIA request to the Obama administration for declined detainers in the Commonwealth of Virginia from January 1, 2014 to September 30, 2015 indicated that 29 detainers were declined. 16 had prior criminal records. I'm citing to you an organization called Immigration and Legal Resources Center, which gives out Phil Burton and Nancy Pelosi awards and talks about ethnic cleansing of communities against Trump. So this is not a conservative organization. They produced a map of local entanglement with ICE, which was current as of December 19, 2016. They identified 4 localities in Virginia which had strict compliance with 287G agreements. They identified about 120 localities which they said are largely defined by their non-compliance with ICE detainers. They identified at that point 2 localities which had basically almost completely disentangled themselves from compliance with ICE detainers. Additionally, on February 6th, Mayor LeVar Stoney of Richmond indicated, quote, in a directive that the Richmond Police Department will not consent to participate with the Immigration Customs Enforcement 287G agreements and will maintain its policy of not inquiring as to the place of birth or immigration status of individuals with whom it comes into contact. The mayor of Charlottesville, Mayor Mike Signer, on a Washington Post article February 6th indicated he was inclined to do the same.
All right, anybody have questions to the patron? I don't think anybody's here to speak to the bill.
each other.
Hang on, anybody in support? For, not on. All right.
Claire Guthrie, Gusty, on behalf of the Assembly of Virginia. So much here that needs to be clarified. One, there are two kinds of quote lawful detainers. One kind is a, hi, we're ICE, we're kind of looking at this person, it'd be really nice if you hang on to them. A civil request with respect to a civil immigration issue. The other is a detainer properly accompanied by a criminal warrant where there's actually a criminal violation of the immigration laws. And when I talked to the Sheriff's Association about why they weren't uncomfortable with this language, they kept telling me that lawful detainer only encompassed that second category, where they show up with a criminal warrant. This bill is written in a way that it's either a circular nullity, or it appears, and something that Delegate Marshall just said caused me to be concerned about, but it does, suggest to sheriffs they can do something which is unconstitutional. There is no law, federal or state, that compels any jail authority to keep someone on behalf of the federal government. When you think about this as a federalism concept, 287G agreements are entirely voluntary. It is categorized in the law as the opportunity for the federal government to delegate its immigration authority to local and state officials, and local and state officials may choose to accept that delegation, for which they get no money. So in this circumstance, the way this is crafted, no sheriff or jail official can constitutionally keep anyone past their local or state prison time or jail time, period, except in response to a lawfully served criminal warrant for another jurisdiction. So it couldn't authorize that. And we already have a law that says that we notify ICE immediately upon somebody being taken into custody of the jail. We have a law that's reprinted here that says we've given our jail authorities and sheriffs the opportunity to release people 5 days early to facilitate transfer to ICE. But nothing about this provision can authorize or require any state or local jail or correctional facility to keep an alien after they've served their state or local sentence if there isn't a criminal warrant that is served. And so it either doesn't do anything because it's a circular nullity, or it appears to suggest the sheriffs could keep people for, quote, 2 days because ICE asked them to, and they cannot do that consistent with the Constitution. And that's been held in a number of court cases. So we oppose the bill either because it doesn't do anything or because it does something unconstitutional. Thank you.
Yes, sir. Please step right up.
Thank you, Mr. Chairman, members of the committee. Kevin Maurer, Virginia Catholic Conference. With all due respect to the patron, the Catholic bishops of the Commonwealth do oppose this bill. We need to ask ourselves why localities adopt the policies that they adopt, and I believe we have to trust them that they do so to keep their communities safe. It's been proven that community policing is a very important part of keeping their communities safe, and yes, there are isolated instances of policy failures across the country, but by and large, I believe that we need to allow localities that discretion in order to maintain trust within the community and keep those communities safe. Thank you.
Thank you. Yes, ma'am.
Marie Giblin with the Virginia Interfaith Center for Public Policy. We are opposed to this bill because detainers are not warrants, and they don't provide a lawful basis for arrest or detention. And ICE often makes mistakes. And finally, that getting ICE involved with public enforcement leads to distrust and unwillingness of the local community to come forward to police, either to report crimes, to be helpful, and for this reason we oppose this bill.
Thank you. Yes, ma'am.
Hi, my name is Laura Gorham. I'm the Research Director for the Commonwealth Institute for Fiscal Analysis. Two things. After the delegate mentioned the map on the floor of the House, I reached out to the authors of that report, Lena Graber from the Immigration Legal Resource Center. She said that her map showed that all but 2 localities in Virginia are currently accepting detainer requests, and that there had been a confusion with the colors as to what is red and orange on the map. And she mentioned she was going to reach out to Delegate Marshall's office. I don't know if she got through. The one other thing I want to say is there's been some questions about the possible cost of holding people for up to 48 hours after they would otherwise be released, if that's what this bill would do. And I'm not clear on whether this bill would do that or not. But Virginia localities, that our local jails receive about 1,500 detainer requests each year. So we went and looked at where those detainer requests have been received and the local jail costs, and found that it would cost about $350,000 a year to hold each of those people an additional 48 hours.
Sounds like there are a lot. There are a lot of people that might be covered by this then.
Well, 1,500 detainer requests was what was received in federal fiscal year 2015.
That we haven't been honored?
I don't know that all of those have not been honored. Virginia localities are able to release folks to ICE up to 5 days early. I don't have information on how many of those folks ICE actually came and picked up.
Okay, so it wouldn't cost that much.
Yeah, that would be like if all 1,500 of the people were held. I don't know how many of them are currently being held, and I don't know how many of them ICE is picking up by the day they would normally be released.
The cost estimate that you all prepared as a guess.
Yeah, as everybody else's is on this bill. Thank you.
Yes, ma'am.
Good afternoon. My name is Elena Kilpatrick. I'm a local attorney and immigrants' rights advocate. Piggybacking off of the cost issue, I wanted to bring to your attention the fact that ICE does make mistakes. And when ICE makes mistakes, and ICE actually detains American citizens, which has happened, localities can be liable. Now, I know several of you are members of the bar, so I would just ask that you quickly look up a couple of cases. Galarza versus Salzik, which is 745 F. 3rd 634. It's out of the 3rd District in 2014. That was a case in which a U.S. citizen was detained, and the federal court said that the case would pass summary judgment and go through, and because the ICE hold was not a lawful detainer, it wasn't a warrant, as the ACLU said, the locality is potentially on the hook, okay? And that's one case out of the 3rd Circuit. There's another case that's not reported, that's I think out of the 1st Circuit, that's Miranda Olivares v. Blackout.
Should you just give us that site?
It's 2014 Westlaw 14-14-305.
Okay.
And I would just encourage you to read these, or have an LA glance over them before you make a final decision. And I can see that if you could change the language, just a tiny language change to warrant, you would fix it. Thank you.
All right, yes, ma'am.
Good afternoon. My name is Jay Martinez with the Virginia Coalition of Latino Organizations. We're opposed to this bill for several reasons. Many of them have already been mentioned. It increases costs to localities by increasing the number of people in local and regional jails, mandates cooperation with detainer requests, which are not court orders, and thus superseding federal laws. Currently, there's no obstacle in Virginia to federal agents doing their job, so we don't completely understand the necessity of this bill. If there were a barrier, then perhaps it would be necessary, but there's not a current barrier to federal agents doing their job here. Local sheriffs are not preventing immigration from doing their jobs. The court orders are fulfilled when there's a signed court order. We hold aliens in Virginia for ICE, and the existing presumption already exists against bail in these cases. So this bill could potentially remove additional judicial discretion. This also prevents programs like electronic monitoring, work release, and substance abuse treatment. And it puts sheriffs and local jail superintendents at risk of lawsuits, as has just been discussed. So we are opposed to the bill for these reasons.
Thank you very much, ma'am. Before we proceed to motions, we have counsel for a reason. Just want to take a moment to hear any issues or concerns that our council may wish to share with us.
The first several concerns, Mr. Chairman, I might describe as technical, certainly not policy. The first is on line 14. It concerns, it speaks of somebody receiving a lawful detainer. A lawful detainer, first, there's no definition of what constitutes a lawful detainer within the bill. We don't use that phrase anywhere else, lawful detainer, within the code. And there appears from the presentation to be some difference in interpretation of what is a lawful detainer. The best I can determine is that for immigration, for ICE purposes, a detainer is a request from ICE to a facility that they be notified prior to that individual's release. So any request from ICE to a jail is a lawful detainer in that it is a request that they be notified before that person is released. And the reason for that is so that ICE can make arrangements to pick that person up. A detainer, as I understand it, does not signify anything one way or the other about that person's immigration status. It does not begin deportation proceedings, and it doesn't mean that that person is going to be deported. By contrast, a notice to appear is indicative of a formal civil filing of a removal proceeding. A detainer is simply a request for notification. The next concern is on that same line, 14, if a jail receives a...
Steve, can I interrupt you? Do you have a suggestion for that?
I do not. No. On that same line, if a jail receives whatever a lawful detainer order is, then they are directed that they shall not release that person. And so what that means is that it eliminates any form of pretrial release under bail conditions or otherwise. It just completely eliminates that. On line 15, it says they shall not release them except to transfer custody of such alien to another facility without defining what is another facility. So if Henrico Jail, well, it just doesn't define what is another facility, nor does it on line 16 define what is an appropriate federal authority. Those are the technical concerns. You've heard the concern voiced already that beginning on line 16, you have what sounds comforting language that no alien will be held in excess of his release date, but it goes on to say, unless federal or state law requires it, which of course is exactly what this would do. It would require that they be held in excess of their release date.
Could we strike state law and say less federal law?
Yes.
Requires it?
Yes.
Would that be a friendly amendment?
Yes.
All right, Senator Stewart moves, Senator Stanley seconds that amendment. All in favor? Signify by saying aye. Aye. All opposed? That amendment is made.
Could you read that again? Strike state law? Strike state law.
17 and 19. All right. Hang on, you have a question with respect to that amendment that we just made? Let's let Steve finish walking through.
Mr. Chairman, we also have this question. The question is, how would a local sheriff determine whether somebody is an alien?
They would ask upon intake, I presume, their status.
Senator Stewart.
Mr. Chairman, when I was
Stewart, please understand that no one can be forced to answer that question. You can ask all day long, but if a person declines to answer, then that's their right.
Then I suppose that if it's not an alien and they are held, then the local government may have liability for violating the civil rights of that person, which mitigates in favor of precaution and care.
Mr. Chairman, you are correct that there are any number of unintended consequences. Essentially, if I understand the bill correctly, what it says to any jailer is, if there's somebody in your population who might be an alien, if you receive a request from ICE to hold them, then once that release date comes, and they're supposed to be released, you can't release them.
Mr. Chairman, could you make another inquiry with ICE? Could you inquire with ICE again, say the date is approaching, and I want to know what the status is, are you going to come get them or not?
Mr. Chairman, Senator Stewart, I don't mean this to be flip. I don't have experience of trying to contact ICE. I don't know what the practical difficulties are. I can't even get through to a clerk when I call the clerk's office. I get that recording that you all had the same experience. So I don't think the answer is that easy of simply contacting ICE.
Mr. Chairman, that's right.
Senator Edwards.
What I understand from sheriffs is they contact ICE, and they say, fine, thanks, bye. They just leave them there. They don't come pick them up. That's the problem. And the state is stuck with holding somebody illegally or beyond the time that they should be released and not being paid. I mean, the federal government, if they would fund these programs, they could pick them up and put them somewhere, but they don't do that. That's the problem.
All right. Steve, is that it?
Yes.
All right. The bill is before us.
Mr. Chairman,
Senator Sturgill.
my question or is surrounding Mr. Benjamin's issue regarding what is a detainer. I just Googled ICE detainer, and there are a couple of forms that come up on the ICE website. One is called an I-247 form, and the other is I-247N form. I don't know if that would address the concerns of what actually constitutes an ICE detainer, but that was what, that's what I was able to find with a quick Google search. So what at least ICE calls a detainer.
Senator Stewart.
Mr. Chairman, despite the picking apart of this bill, it seems to me to be a reasonable process for us to deal with the situation, so I said the bill be reported.
It's been moved and seconded, the bill be reported as amended. Any further discussion? All in favor, signify by saying aye. Aye. All opposed?
No.
All roll.
Senator Sadlaw.
No.
Senator Norman. Senator Howell. Senator Lucas.
No.
Senator Edwards.
No.
Senator McDougal.
Yes.
Senator Stewart.
Yes.
Senator Stanley.
Aye.
Senator Reeves.
Aye.
Senator Chapin.
Yes.
Senator Deeb.
No.
Senator Sturgill.
Yes.
Senator Peterson.
No.
Senator Peach.
Yes.
Senator Obenshain.
Yes.
Yeah, 6 minutes.
The bill is amended as reported. Thank you very much. Delegate Marshall. And Delegate Cillian, I think we're going to take care of you. Okay? Thank you. Delegate Marshall.
Thank you very much. He's a charming one.
We know.
Everyone knows that. I was going to say something about that. So let me tell you, House Bill 1699. So a little history of how we got to this point. The assistant attorney in the city of Danville asked me to put this bill in last year. And the bill last year was a statewide plan, and the House courts did not like that. It was too broad. So what we did is we put the bill in study in the Virginia House Housing Commission to come up with a pilot plan, and this is a pilot plan for the city of Danville only.
Delegate, and I don't mean to be rude, let me just see if I can give you a little assistance. This is, provides that, that for small transfers of $50,000 or less, you gotta go through gotta let the city know, right?
That's exactly right.
The clerk support it?
Yes.
The realtors support it?
Yes.
All right.
Farm Bureau.
Farm Bureau supports it, and it's a pilot project. Anybody have any questions? Anybody in the audience wish to be heard in connection with this?
Can I ask a question?
Yes,
That may be true, but so what's gonna happen is if someone tries to transfer a deed, like say from a husband to a husband and wife, like attends the entirety, they have to report that there are no taxes to be paid?
Let's, I have an expert witness.
Okay. So you can't get married? It's an anti-family bill. Chip, you want to defend it?
So this was worked extensively in the Housing Commission, and it is limited to a pilot project in the city of Danville. $50,000 property transfers or less, assessed value. And the idea is that there are people, and again, anybody that uses a settlement agent who's licensed or an attorney at law will always collect the real estate taxes at closing before the transfer to the buyer. Right. It's only people who are trying to game the system and transfer from NTA to NEB without paying the taxes, that the clerk would kick that fee back unless it had the finance director's certificate that the real estate taxes have been paid.
Okay, one question if I might, Mr. Chair.
Yes.
Let's say you have a piece of property, either you want to put it in a trust, or you got married, or you got divorced, but you're looking to basically retitle the property without doing a form of conveyance. Will this affect that type of transaction?
Mr. Chairman, I would say to Senator Peterson, it would affect any transaction that was not done through a settlement agent where the taxes are paid. It would affect any transaction under $50,000 assessed value for the total property, counting improvements.
Sir Edwards.
How is this valid? I mean, you have a property, it still has a tax lien on it, you want to transfer it, so your property's transferred with the lien on it. But if everybody knows what they're doing, how can you prevent somebody from transferring title? Because you need to record it in order properly to transfer title. Why is it valid?
So, Mr. Chairman, I would say that the purpose of the pilot project modeled upon legislation in North Carolina, which, as Delegate Marshall will tell you, I wasn't wild about this bill last year, right? But it's in a posture where it's modeled after North Carolina legislation, and what it does is to prevent somebody from basically gaming the system, transferring one entity to another without paying the real estate taxes. And it allows the city of Danville, in this case, as a distressed locality, to be able to grab, and again, less than $50,000 is the assessed value on these transfers. So it's a very limited universe of transfers in the city of Danville.
Mr. Chairman, I can see just notifying the city that your taxes on it haven't been paid and they're gonna transfer the property. If you wanna do something, you can do it. But I'm not sure it's valid to say I can't transfer it with lien on the property.
Mr. Chairman, I would say to Senator Edwards, it's not that they can't transfer it. They can, of course, transfer it if they choose to. You don't have to record a deed transfer. It would not be subject to recordation by the clerk unless it had this certificate at the top only on the universe of properties under $50,000. And again, this model has worked in North Carolina successfully in the city of Danville with the number of distressed properties that they had wanted to try this, which is why we've ended up with a 3-year pilot project with a report back to the Housing Commission to see if this works.
All right. Anything else?
12% of the housing in Danville is vacant.
All right. Senator Stewart, Senator Stanley. Senator Stanley moves the report, Senator Stewart seconds. Feel compelled to say anything? I would not. All right. All in favor of reporting, signify by saying aye. Aye. All opposed, no reports. Thank you.
Thank you.
And, I'm sorry. 3. Delegate Peace, I'm sorry, and Delegate Bell, I'm sorry. I think you've got to go quick one.
I hope so.
very efficient staff.
1951.
House Bill 1951 was
Good year,
passed
year
by.
Senator Stewart was born.
No comment. House Bill 1951 was passed by the House Court of Justice Committee with a substitute and has come over to you for your consideration. And it comes up as a result of my service on the Criminal Justice Services Board, where we realize that there's some structural issues there. We've got 28 members. This bill will increase it by one member representing community interest, and it also substitutes the Virginia Association of Campus Law Enforcement Administrators for the Virginia Crime Prevention Association, which is now defunct. It also adds and designates that community interest position to the Committee on Training. That is a companion to budget language that we have in the House, which directs ECJS to update training standards, which has not happened in 20 years, or approximately 20 years. That's the essence of the bill.
And give us a little bit of comfort by telling us that all of our legislative appointees support this.
All of our legislative appointees, well, they voted for it.
All right, even our Senate legislative appointees.
I have not heard any objection to the bill.
The one with Congress.
Well, he's hard to reach these days. He's very busy sorting out affordable health care.
All right. Anybody wish to be heard in support of or in opposition to this?
ECJS is, say thank you to the delegate.
All right, ECJS loves it. Any questions of patron? Bills before us. Been moved and seconded this fine bill will be reported. All in favor, signify by saying aye. Aye. All opposed, that bill is reported. Thank you very much. Delegate Bell.
Thank you, Mr. Chairman.
1604.
1604 deals with termination of parental rights for children in foster care. Mr. Chairman, I can tell you that the bill amends the code of Virginia to be consistent with federal language, and that without the implementation, the department may be at risk of potential federal penalties and lost Title 40 funding. That's about the extent of my agency speak, but I do have an expert who can do it succinctly for you.
All right. Let's hear from your expert.
Yes. Good afternoon, Mr. Chairman. Carl Ayers, Director of Vision and Family Services for the Department of Social Services. This bill is one of our annual changes at federal level that we need to bring Virginia code in compliance with the end of it. We have worked with all the advocates and everybody to bring the language into consistency and address any concerns. And really all it does is just make the language consistent with federal language so we can continue to pull down federal 40 funds. If you have specifics, I'll go further, but that's the essence of the bill.
And I know that this went through our work group process, and there were some questions, but as I understand it, it was determined that the language about which there were questions was required by federal law, and to the extent that they can be addressed, they have been. I think so. To the extent that we understand your purpose, I think we're pretty square with it. Okay, very good. All right. Anybody have any questions of the patron or the witness? Anybody else wish to be heard in connection with this bill? Bill's before us. It's been moved and seconded, the bill be reported. All in favor, signify by saying aye. Aye. All opposed, bill is reported. Thank you.
Thank you, Chairman.
And Senator Chapin, you, I think, wanted to report in connection with Delegate Williams' bill.
Yes, sir, Mr. Chairman. I talked to Delegate Williams, and he's been in touch with the Sentencing Commission and has come up with a way outside the passage of the bill to get this information reported. My understanding is the Sentencing Commission has agreed to follow that format, and that the judges, the circuit court judges that are going to be participating are going to be working with identifying these cases on a separate sheet that will be prepared, and we'll be turning that in to the Sentencing Commission. And if this doesn't work this way, he's indicated to me that he would be back with a bill or a very similar bill next year. So he's asked that the bill be gently passed by this year.
All right. Motion, if I now, but